welcome back. Let me fast forward and just take this a little, bring in this dimension, because, you know, there are a lot of people who sit back and just wonder. Yes, they've looked at the ACJA 2015. It talks about the processes that the arresting officer or the person arresting has got to carry out, read them, their Miranda rights. Many have even asked. We haven't even seen any video, any material from the SSS or the police, if at all they could also pop up with those kind of information. What if at the end of the day we see material or evidence or information of things that pop up from that particular raid? Wouldn't the narrative completely change, especially in the light of the fact that lots of people saying we actually need to do something about corruption in the judiciary?
Mr. Chamberlain, I don't think that the question is whether money was found or not. As a sting operation, money ought to be found, and that is the reason why SSS, as they call themselves DSS, was able to know and tell us that there was $2 million somewhere in the house and it has moved. Perhaps microchips were attached to the monies. Perhaps they planted it there. Those are part and parcel of sting operations. Sting operations portends that perhaps there was no sufficient evidence, but in order to implicate someone, you set that person up by feigning an urgent provocateur, so, as an example, to instigate that person or to catalyze that person into committing a crime.
So your point now is that the SSS didn't go about this in the right way?
Absolutely. SSS started from the wrong footing. They ought not to, if it had been an EFCC activity, I don't think that the issue would have been difficult to accept. But so, for the SS to have done it, it raises a lot of questions.
You know, we go back to the issue. We go back to the issue, and it has to do with the clause there in the Act that says the prevention and detection within Nigeria of any crime against the internal security of Nigeria.
Yes.
And that, I'm quite sure you must have heard that argument that it falls within that because there is an intention, and they also believe that there's a crime.
That's a very laughable. It's a laughable. That, I said it earlier on. It's a populist argument. It's an argument that Mr. Ekondia meant to get into the psychology of the population, who are already crying against corruption. The last the last paragraph of that section you are reading empowers the president or the National Assembly to determine what the SSS can do with regards to national security in terms of intelligence. Pursuant to that, and that's a precedent. Pursuant to that, General Abdulsalami Abubakar in 1991, by instrument number 1, made certain laws, certain regulations, brought out certain regulations that expanded the authority and powers of the SSS. Now, that is the way to go, pursuant to that paragraph. Not by the president making a call to the SSS director to go ahead with something outside of the purpose. There is no way you can stretch bribery and corruption to involve national security. It is very difficult. Okay. The way to stretch it is that the president will come out and make this instrument pursuant to that subsection, and which is what this man did, Abdul Salami did, that now empowers DSS to profile, to look at money laundering in terms of support to terrorism, and in terms of support to espionage. So this is where they got that power, not for the original act. Now, I want to also raise a third point that stood out, and that third point is that it is very heartening. It is very, very encouraging to see that the NJC is standing up to the executive. It is very important in democracy for the judiciary to stand up to other arm of government. It's also very essential that other arms of government should be able to stand up, look face to face to each arm of government and tell them
even when they have some glaring, evidence, perhaps
that is why they are
alleged corruption
against. It is self-regulatory.
But if the self can't cleanse itself all the while, then
on what principle, what basis are you saying? Is it the executive that is judging that the self is not self?
But the physician in this case couldn't heal thyself. So
no, if it is, you see, people are looking at crime and professional misconduct. You have to convince the self-regulatory body, the independent body, that there is a need to take an action. When they take the action, you can take it up in crime. Most times again, you will see that the villain is usually the victim. The victim comes out to become the villain. The villain acts in such a way that he makes himself to look like the victim. That is where
we'll come to that in a minute. Yes. Because many will ask, how are we going to fight corruption if we keep going without these legal scenarios? But let's bring in Mark on this one before we go a little further on the same matter. Mark, what?
Well, we're definitely talking about, I think that my thoughts are just a continuation of what your thoughts are, Chamberlain. Because Mr. Ikeji has differentiated between crime and misconduct. Are you saying then that if the NJC is empowered to dismiss or retire a judge over misconduct, a crime cannot be established against that same judge unless the NJC has found him or her guilty over some misconduct? Is that what you're implying?
No, that's not what I'm implying. The situation is very clear. When you bring out an allegation against a judge, all you need to do is to place it before the NJC, and the NJC with its internal mechanism will investigate. And with the publication of the NJC, it investigated. You must let the NJC have its way within its jurisdiction, or else you are doing its job for it. Who will check the DSS? Who will check the executive if it continues to be the only check available in the society?
No, but they are not the only check.
So who checks the SSS now? If the SSS is going wrong, who checks them? So where there is crime, in answering Mokpe's question, where there is crime, absolutely you must proceed to lay charges against judges. For example, if the SSS has decided to go to court and arraign these judges, just go to their houses or their offices, invite them to your station, lay the evidence before them, let them give their statements with their lawyers, and take them to court, arraign them. That is a decent way of handling judicial independence.
Let's paint the scenario.
Yes, please.
Now, assuming the judges were held, just thinking now, you have held issue over the fact that the DSS was not empowered to be fighting corruption in the first instance.
Yes.
Now, assuming the DSS had held the judges over charges of espionage,
yes.
Are you saying that first of all they must go to the NJC first before the NJC would say that there's been some misconduct before the DSS can act on that? Is that the process you're prescribing?
No, that's not the process I'm prescribing. If there is evidence of espionage, money laundering, bordering on terrorism against any judge, the DSS has every power to investigate it and release the information, note my word, to the appropriate agency to prosecute them, which is the Attorney General. The Attorney General will instigate the process, will institute the process of arraigning these judges for espionage. Yes, because the power of DSS involves espionage, they can go ahead and arrest the judges upon due process, ask them to explain themselves with regards to their espionage activities.
So,
yes.
Now that there's as it is now, because since that inaugural meeting that NGC had in 2000 up until now, I think they said they've had Sam Kagbo's article saying, I think 1,808 petitions, including against the CJN.
Yes.
And then you have members of the public who say, look, something needs to be done about fighting corruption, even in the judiciary. Because you understand the very crucial role, how very important that judicial leg is in the sustenance of democracy. Now we know we need to fight corruption, and I mean, you always say justice not just to be done, but it has to be seen to be done.
Yes.
So if all of these processes you're stipulating takes us round in circles,
yes,
and then
it doesn't take us round in circles.
No, what kind of progress have we made?
Have you dissected the arrest procedure? Have we dissected
as stipulated where in the criminal ACJA?
Yes, even before the SCJ, the CPA and the CPC in the north. Have we dissected the investigative and investigation procedures? Have we dissected the prosecutorial procedures?
So what kind
have
of
we dissected the defense procedures? What I am saying is that the problem is not just the judiciary, but the judicial process. You have had cases, good cases, where there is poor prosecution, and the blame will be put on the judge, because the judge is not a Father Christmas. It is what is brought before the judge.
Yeah, but Mr. Ikeji, are you saying there isn't corruption even among the judges?
I have been a victim of judicial corruption, and I'm stating this on national TV. I have filed a case, and that case, I don't know if I should mention it. That case has to do with two members of of INEC, who were members of a political party then during the last dispensation. I went to court against these people. I said these people are members of PDP then, and they ought not to be allowed to supervise INEC as national commissioners or as REC. The judge who had the authority to sign my processes in court said this case he will not take it. This case he will not accept it. That is judicial corruption. He has already judged my case even before hearing it in open court. I have been a victim of judicial corruption in several other instances. Now, we are not also going to close our eyes to certain situations. These situations are given you give them as an example from the statements made by the two Supreme Court justices. You can't sweep that under the carpet. You can't sweep that under the carpet. I have appeared before Justice Adeniyi Ademola, and I stand here to say I have not seen any reason to say that this man is not sound. I know Nnamdi Dingba. Nnamdi Dingba is a doctorate degree holder, and I'm not saying that because of his degree is good. He's a brilliant judge who has just gone into the judiciary.
But don't you think that
people have given orders against the DSS?
You don't think we should wait until maybe we see the priors when they are charged to court? Will that in any way?
You see, I have no qualms. A lot of us do not have qualms.
You haven't seen the evidence.
Yes, a lot of us do not have qualms taking them to court.
Okay, but you think it's about the process?
I think it's about the process. It is the process that causes tyranny. Hitler emerged a tyrant as a result of corruption of the process.
Okay, Mr. Ikechukwu Ikeji, a legal practitioner, we appreciate your coming on this morning.
Most
well, we'll be back in just a moment. Join us again.